the Librarian of Congress released their new proposed rulemaking. Well, what the heck is that? That's super interesting, right? You want to know what a proposed rulemaking is. So in the world of copyright, we have various leadership positions. In the Copyright Office itself, the director of the Copyright Office is the Register of Copyrights. The acting Register of Copyrights is currently Karen Temple. So when you see in the document we're about to read, the acting Register of Copyrights has recommended, that's that person. That's Karen Temple. When you see that the Librarian of Congress recommends, this is the Librarian of Congress, Carla Hayden. The Librarian of Congress is the head of the Library of Congress, appointed by the President for a term of 10 years. They appoint the U.S. Poet Laureate, award the Gershwin Prize for Popular Song. They have broad responsibilities around copyright, extending to electronic resource and fair use provisions outlined in the Digital Millennium Copyright Act. The librarian determines whether particular works are subject to DMCA prohibitions regarding technological access protection. You'll see them referred to as technological protection measures. So, what we are going to be looking at then is this document that is scheduled to be published on the Federal Register on 10/26, which was Friday, making it an official rulemaking document from the Librarian of Congress. The librarian, as we just heard, is tasked with making certain exemptions to the DMCA, so we're going to be discussing what the new and renewed exemptions to the DMCA's technological protection measures and access control part. The DMCA protects certain copyrighted works by also allowing protection under copyright law for the technological protection measures, or DRM, digital rights management, that protect them. Now, this leads to some weird scenarios that we'll definitely be going over in detail here, but it leads to some weird scenarios where people have been trying to use copyright to protect things that shouldn't be protected by copyright law, and copyright has a purpose. If copyright is not being used to further the creative arts or scientific works, then its purpose is not being furthered, and maybe a technological protection measure is not being used in furtherance of copyright, and so it shouldn't be valid. And so some of this helps clarify that. You'll see what we're talking about. Let's jump into it now. In this final rule, the Librarian of Congress adopts exemptions to the provision of the Digital Millennium Copyright Act, DMCA, that prohibits circumvention of technological measures that control access to copyrighted works, codified in the U.S. Code. As required under this statute, the Acting Register of Copyrights, following a public proceeding, submitted a recommendation concerning proposed exemptions to the Librarian of Congress. After careful consideration, the librarian adopts final regulations based on the Acting Register's recommendation, and this will be effective today. So if you are watching this, these rules are now effective. The Librarian of Congress, pursuant to 1201A1 of Title 17 U.S. Code, has determined in this Seventh Triennial Rulemaking, that means it's the 7th time it's happened, it happens every 3 years, that the publication against circumvention of technological measures that effectively control access to copyrighted works shall not apply to persons who engage in non-infringing uses of certain classes of such works. And so we're going to be talking about the classes of people or uses that get protected or exempted or whatever. The below discussion summarizes the rulemaking proceeding and register's recommendation, announces the librarian's determination, and publishes the regulatory text specifying the exempted classes of works. Congress enacted the DMCA in 1998 to implement certain provisions of the WIPO copyright and WIPO performance and phonogram treaties. Among other things, Title I of the DMCA, which added a new Chapter 12 to Title 17, prohibits circumvention of technological protection measures employed by, on, or behalf of copyright owners to protect access to their works. Section 1201A provides that no person shall circumvent a technological measure that effectively controls access to a work protected under Title 17. To circumvent a technical measure means to descramble a scrambled work, decrypt, otherwise avoid, bypass, remove, deactivate, impair a technological measure without authority. A technological measure that effectively controls access to the work is one that, in the ordinary course of its operation, requires the application of information or a process or a treatment with the authority of the owner to gain access to the work. 1201A1 also includes what Congress characterizes as a fail-safe mechanism, which requires the Librarian of Congress, following a rulemaking proceeding, to publish any class of copyrighted works as to which the librarian has determined that non-infringing uses by persons who are users of a copyrighted work are or likely to be adversely affected by the prohibition against circumvention in the succeeding 3-year period, thereby exempting that class from the prohibition for that period. So the law says the Librarian of Congress has to do this, hold this rulemaking proceeding. We'll talk about what a rulemaking proceeding is in just a moment. The librarian and the now acting Register of Copyrights, because we didn't used to have a Register of Copyrights, that's a new thing. The librarian and the acting Register of Copyrights work together to hold this proceeding and enact these rules. Now, normally, rulemaking is only done by administrative agencies, and I'm not sure that the Librarian of Congress is actually an administrative agency. Well, without going into hours and hours of administrative agencies are basically delegated power in the executive branch. So the FCC handles communications, the FAA handles aviation, the IRS handles federal taxes. These are administrative agencies. Well, the Librarian of Congress has a similar rulemaking process for this evidence-gathering procedure regarding exemptions to the Digital Millennium Copyright Act. And so they have this whole video about it, and you can go watch it, and we're not going to do that here. But if you wanted to, you can go check this out. I'll post this link in the chat. And if I remember, in the description as well. You can find it on the Library of Congress website. Just search for Librarian of Congress Rulemaking Procedure. The librarian's determination to grant an exemption is based upon the recommendation of the Register of Copyrights, who conducts the rulemaking proceeding. The Register, in turn, consults with the Assistant Secretary for Communications and Information of the Department of Commerce, who oversees the National Telecommunications and Information Administration. So when you see NTIA, that is the National Telecommunications and Information Administration, in the course of formulating her recommendation. The primary responsibility of the Register and the Librarian in the rulemaking proceeding is to assess whether the implementation of access controls impairs the ability of individuals to make non-infringing uses of copyrighted works. To do this, the Register develops a comprehensive administrative record using information submitted by interested members of the public and makes recommendations to the librarian concerning whether exemptions are warranted based on that record. This is the notice and comment part of the rulemaking procedure. Public notice is given and comments are accepted, and you'll see more of that here. This is all background, and I realize that this is not the most interesting part of it, but this will make the context of the most interesting parts of it mean that much more to you, I think. So trust me on this one. The librarian and the Register must consider the availability for use of copyrighted works, the availability for use of works for nonprofit, archival, preservation, and educational purposes, the impact that the prohibition on the circumvention of technological measures applied to copyrighted works has on criticism, comment, news reporting, teaching, scholarship, research, mostly fair uses, the effect of circumvention of technological measures on the market for or value of the copyrighted works, and such other factors as a librarian considers appropriate. Significantly, exemptions adopted by rule under Section 1201A1 apply only to the conduct of circumventing a technological measure that controls access to a copyrighted work. Other parts of 1201, by contrast, address the manufacture and provision of or trafficking in products and services designed for circumvention. 1201A2 bars trafficking in products and services that are used to circumvent technological measures that control access to copyrighted works. For example, a password needed to open a media file. 1201B bars trafficking in products and services used to circumvent technological measures that protect the exclusive right of the copyright owner in their works. For example, technology that prevents works from being reproduced. The Librarian of Congress has no authority to adopt exemptions for the anti-trafficking prohibitions contained in A2 or B. More broadly, activities conducted under the regulatory exemptions must still comply with other applicable laws, including non-copyright. Section 1201D, which exempts certain activities of nonprofit libraries, archives, and educational institutions. 1201E exempts lawfully authorized investigative, protective, information security, intelligence activities of a federal or state government. 1201F exempts reverse engineering activities to facilitate interoperability. 1201G exempts certain types of research into encryption technologies. 1201H exempts certain activities to prevent access to minors to material on the internet. And 1201I exempts certain activities solely for the purpose of preventing the collection or dissemination of personal identifying information. And 1201J exempts security testing of computers and computer systems. The Rulemaking Standards section says that evidence must, on a whole, show that it is more likely than not that users of a copyrighted work will, in the succeeding 3-year period, be adversely affected by the prohibition on circumvention in their ability to make non-infringing uses of a particular class of copyrighted works. To establish the case for an exemption, proponents must show, at a minimum, that the uses affected by the prohibition on circumvention are or are likely to be non-infringing, that the result of a technological measure controlling access to the copyrighted work is likely to cause an adverse impact on those uses. The exemption adopted as part of the rulemaking must be defined on a particular class of works. Accordingly, it can be appropriate to refine a class by reference to the use or user in order to remedy the adverse effect of the prohibition and to limit the adverse consequences of an exemption. History of the Seventh Triennial proceeding. The office created video tutorials explaining the rulemaking process, issued a notice of proposed rulemaking earlier to give parties more time to participate, and offered increased opportunities for participant input, including through an established procedure for transparent ex parte meetings. Someone might want to send this section to Ajit Pai because this is more or less how you're supposed to conduct a rulemaking proceeding. The office initiated the Seventh Triennial Rulemaking Proceeding through a Notice of Inquiry on June 30th, 2017. The Notice of Inquiry requested petitions for renewals, petitions in opposition to renewals, petitions for new exemptions. The office received 39 renewal petitions, 5 comments regarding the scope of renewal, and 1 comment in opposition to renewal of a current exemption. The office also received 23 petitions for new exemptions, including 17 seeking to expand certain current exemptions and 6 for new exemptions. The summary of the registrar's recommendations, their renewal recommendations specifically. The acting register received petitions to renew every one of the current exemptions from the 6th Triennial Rulemaking 3 years ago. They are literary works distributed electronically, assistive technologies. These are an exemption for literary works distributed electronically for use with assistive technologies for persons who are blind. Literary works, compilations of data generated by implanted medical devices. So this is regarding whether you can read data from an implanted medical device. We'll go over these in much more detail in a moment. Computer programs, including the unlocking of cell phones, tablets, mobile hotspots, or wearable devices. Computer programs, the jailbreaking of smartphones, smart TVs, tablets, other all-purpose mobile computing devices. The diagnosis, repair, or lawful modification of motorized land vehicles, again regarding computer programs. More computer programs regarding security research, Security researchers provide an example of a recent security conference in which thousands of participants relied on the existing exemption to examine and test electronic voting devices, the results of which were reported to election officials to improve the security of voting systems. The exemption for computer programs for 3D printers to allow alternative feedstock, as in alternative 3D printing material, an exemption for video games requiring server communication for continued individual play and preservation of games by libraries, archives, and museums, audiovisual uses for educational and derivative uses for colleges and universities to use motion picture clips for instruction, primary and secondary schools, same thing, massive open online courses, same thing, and educational programs operated by libraries, museums, other nonprofits, multimedia ebooks offering film analysis, documentary filmmaking, and non-commercial remix videos are all up for renewal for audiovisual cues or uses or short clips. The Organization for Transformative Works advocates for the non-commercial video exemption in the past triennial rulemakings and has heard from a number of non-commercial remix artists who have used the exemption and anticipate the need to use it in the future. New Media Rights stated that it has spoken to a number of non-commercial video creators who have relied on the exemption and will do so in the future. The new or expanded classes are a proposed Class 1 in audiovisual works for criticism and comment. Several petitions sought an expansion of the existing exemption for circumvention of access controls on short portions of DVDs, Blu-rays, and other digitally transmitted video for purpose of criticism and comment by various users, including creators of non-commercial videos, college and university faculty and students, faculty of massive online open courses, documentary filmmakers, and for non-fiction multimedia ebooks offering film analysis. The Copyright Office has grouped these petitions into one class. The current exemption expressly permits the use of screen capture technology and allows circumvention only where the user reasonably believes that screen capture or other non-circumventing alternatives are unable to produce the required level of high quality. They go into the various recommendations. I'm going to skip right to the conclusions. The acting registrar proposes for Class 1, and the librarian, I think, adopts, that motion pictures, including DVD's content scrambling system, Blu-rays, advanced access control system, and digital transmissions protected by a protection measure, but not AACS2, not listed here, as long as the person reasonably believes that non-circumventing alternatives will not produce the high level of quality content, as long as they are for documentary filmmaking, non-commercial videos, including videos produced for a paid commission if the use is non-commercial, non-fiction multimedia ebooks, and educational purposes by colleges and universities, K-12, educators and students, massive open online courses, and nonprofit digital media literacy programs offered by libraries, museums, and other nonprofit entities with educational missions are allowed to circumvent DVD, CSS, and AACS, and other technological protection measures, but not AACS2. It'll be listed here later. You'll see it. I just want to make sure that's clear. Proposed Class 2 is audio-video works, accessibility for disability services professionals at educational institutions to create accessible versions for students with disabilities by adding captions or other audio descriptions. Nearly all educational institutions are subject to the Americans with Disabilities Act, Section 504 of the Rehabilitation Act, and the Individuals with Disabilities Education Act, which require them to accommodate students with disabilities. The acting register of copyright and the librarian adopt, therefore, that motion picture protection can be circumvented by a disability service, office, or other unit of a kindergarten through 12th grade educational institution, college, or university engaged in or responsible for the provision of accessibility services for students. The educational institution must determine, after reasonable effort, that an accessible version cannot be obtained at a fair price or in a timely manner, and the accessible version needs to be stored in a manner that is reasonably calculated to prevent unauthorized further dissemination of the work. Proposed Class 5, computer programs unlocking, that is, circumvention of access controls on computer programs for the purpose of enabling a wireless device to connect to a different mobile network provider. This is the cell phone exemption. The acting register recommends that computer programs that enable the following types of lawfully acquired wireless devices to connect to a wireless telecommunications network when circumvention is undertaken solely in order to connect to a wireless telecommunications network, and such connection is authorized by the operator of such network. This applies to wireless telephone handsets, as in cell phones, to all-purpose tablet computers, to portable mobile connectivity devices such as hotspots or wireless broadband modems or similar devices, to wearable wireless devices designed to be worn on the body such as smartwatches and fitness devices. Jailbreaking is also being protected, that is, the process of gaining access to the operating system of a computing device to install or execute software that could not otherwise be installed or run on the device, and to remove pre-installed software that could not otherwise be uninstalled. In this proceeding, the Electronic Frontier Foundation filed a petition seeking to expand the current exemption by adding voice assistant devices such as Amazon Echo and Google Home to the categories of devices covered by the exemption, and to allow jailbreaking not only to install, run, or remove software, but also for the purpose of enabling or disabling hardware features on the device. The NTIA agrees that jailbreaking voice assistance is unlikely to harm the market for copyrighted works, which was one of the opposition's arguments, noting that there is no evidence of market harm for the devices covered by the current exemption. Accordingly, the acting register recommends the librarian adopt the following exemption: computer programs that enable voice assistant devices to execute lawfully obtained software applications where circumvention is accomplished for the sole purpose of enabling interoperability of such applications with computer programs on the device, or to permit removal of software, and is not accomplished for the purpose of gaining unauthorized access to copyrighted works. Here's the one that everybody's talking about on the internet: Proposed Class 7 computer programs repair, allowing for circumvention of access controls controlling the functioning of motorized land vehicles for purpose of diagnosis, repair, lawful modification of a vehicle. Okay, this is for vehicles, to allow an additional range of activities. The acting register grouped them into the following categories: removing the current limitation prohibiting circumvention of technological protection measures to access computer programs primarily designed for the control of vehicle telematics and entertainment systems, expanding the exemption to apply to other types of software-enabling devices, including appliances, computers, toys, and other Internet of Things devices, extending the exemption to allow circumvention by third-party service providers, and in particular independent vehicle repair shops for purpose of diagnosis, repair, and lawful modification, and allowing the acquisition, use, and dissemination of circumvention tools in furtherance of diagnosis, repairs, and modification. The acting register first considered proposed expansions within the context of motorized land vehicles and then addressed expansion of the exemption to other types of devices. Regarding motorized land vehicles, proponents asserted that diagnosis, repair, and lawful modification of vehicle telematics and entertainment systems are fair uses and non-infringing under Section 117. Proponents contended that because these systems are increasingly integrated with functional vehicle firmware, access is necessary to engage in the diagnosis, repair, and lawful modification of vehicle functions, activities the register found are likely non-infringing in recommending the existing exemption. Proponents sought access to telematics systems in order to obtain diagnostic data. Proponents asserted that vehicle firmware is effectively useless outside of the vehicle, with essentially no separate market for the software apart from the vehicles. In addition, proponents suggested users should be permitted to access storage capacity in vehicle entertainment systems and to repair infotainment entertainment modules. In response, opponents contend that the proposed activities are not favored under fair use because access to entertainment and telematic systems could allow unauthorized access to expressive or protected copyrighted content. Opponents also suggested that once the firmware on some devices is accessed, it is compromised such that it can no longer prevent piracy. Concerning third-party assistance, several proponents proponents requested that the exemption specifically permit third parties, such as repair services, to assist owners in carrying out the authorized activities. The acting register then recommends two separate exemptions, one relating to motorized land vehicles and one related to the repair and maintenance of additional categories of devices. Regarding motor vehicles, the recommended exemption removes the requirement that circumvention be undertaken by an authorized owner and instead provides that it apply where such items are lawfully acquired. The acting register also recommended removing the language excluding access to computer programs designed for the control of telematics or entertainment systems. Due to increasing integration of vehicle computer systems since the 2015 rulemaking, retaining this limitation may impede non-infringing uses that can only be accomplished by incidentally accessing those systems. The recommended exemption specifically excludes access to programs accessed through a separate subscription service, while the broadened exemption permits incidental access to a vehicle infotainment system. It provides that such access is allowed only to the extent that it is a necessary step to allow the diagnosis, repair, or lawful modification of a vehicle function, and includes the additional requirement that circumvention may not be accomplished for the purpose of gaining unauthorized access to other copyrighted works. Accordingly, the acting register recommends the librarian adopt the following exemptions. Computer programs that are contained in and control the functioning of a lawfully acquired motorized land vehicle, such as a personal automobile, etc., except for when programs are accessed through a separate subscription service, when circumvention is a necessary step for diagnosis, repair, or lawful modification, they are now exempt. Computer programs that are contained in or control the functioning of a lawfully acquired smartphone or home appliance or home system, such as a refrigerator, thermostat, HVAC, or electrical system, when circumvention is a necessary step, etc., for the purpose of maintenance or repair, they are also exempted. So that also includes a category for home Internet of Things devices, such as a refrigerator, thermostat, HVAC, electrical system. That's really interesting. Proposed Class 9 is for software preservation. TPMs applied to computer programs can interfere with preservation activities. The Software Preservation Network and the LCA filed a petition that would allow libraries, archives, museums, and other cultural heritage institutions to circumvent TPMs on lawfully acquired software for the purposes of preserving software and software-dependent materials. Proponents advance three bases for their proposed activities to be non-infringing: 1, fair use; 2, Section 108 exemption for library and archival replacement copies; and 3, Section 117A exception for archival copies of computer programs. Accordingly, the acting register recommends that the librarian adopt the following exemption: computer programs except video games that have been lawfully acquired and are no longer reasonably available in the commercial marketplace solely for the purpose of lawful preservation of a computer program or of digital materials dependent on a computer program as a condition of access by an eligible library, archive, museum, where such activities are carried out without any purpose of direct or indirect commercial advantage, and the program is not distributed or made available outside of the physical premises of the eligible library, archive, or museum. So then this next one does cover video game preservation, in case you were concerned. Class 8 proponents sought expansion of the provisions in the existing exemption that allowed eligible institutions to circumvent access controls to preserve video games for which external server support has been discontinued. Some video games require a network connection to a remote server operated by a game's developer before the video game can be accessed and played. When the developer takes such a server offline, the game can be rendered unplayable or limited to certain functions, such as single-player play or multiplayer play on a local network. The current exemption allows an eligible library, archive, or museum to circumvent this type of authentication mechanism to preserve a lawfully acquired game in a complete form. The Museum of Art and Digital Entertainment, MADE, filed a petition seeking to expand the exemption to allow circumvention of access controls on video games that need access to creative content stored on a remote server, which MADE refers to as online games. Opponents contend that proponents wish to engage in recreational play that functions as a market substitute. The acting register did not recommend an exemption to allow for instances where the preservation institution lacks lawful possession of the server software. She found the record insufficient to support a finding that the recreation of video game server software, as described by proponents, is likely to be fair use. A number of scenarios described by proponents do not involve preserving server software that is already in an institution's collections, but instead appear to involve something more akin to reconstructing the remote server software. She found that this activity distinguishes proponents' request from the preservation activity at issue in case law upon which they relied. Moreover, she noted the reconstruction of a work implicates copyright owners' exclusive right to prepare derivative works. Accordingly, the acting register recommends the librarian adopt the following exemption. Video games in the form of computer programs embodied in a physical or downloaded format that have been lawfully acquired as complete games, where the copyright owner or its authorized representative has ceased to provide access to an external computer server necessary to facilitate an authentication process solely for the purpose of permitting access to the video game to allow copying and modification of the computer program to restore access to the game for personal local gameplay, or for permitting access to the video game to allow copying or modification for a library, archive, or museum, and video games in the form of computer programs that have been lawfully acquired, etc., for the purpose of preserving the game in a playable form by an eligible library, archive, or museum. Computer programs used to operate video game consoles solely to the extent necessary for an eligible library, archive, or museum to engage in preservation activities. Then they go into proposed Class 10, Computer Programs Security Research. The office received multiple petitions to expand the existing exemption allowing circumvention for the purpose of conducting good faith security research on certain types of software-enabled devices and in machines. Proponents argue that the current language contains limitations that unnecessarily restrict its scope, as well as ambiguities that chill legitimate research. These include a provision limiting the exemption to specified categories of devices, a requirement that a device be lawfully acquired, a requirement that circumvention be solely for the purpose of good faith research, a requirement that the research be carried out in a controlled environment, a requirement that information derived from the activity be used primarily to promote the security or safety of the class of machines, a requirement that circumvention not violate any applicable law. Proponents maintain that the proposed activity is non-infringing on one or more grounds relied on by the Register in 2017, including Section 2015, including Section 117 and fair use. The acting register found that good faith security research involves accessing devices beyond those covered by the current exemption, and it is likely to be a fair use. Accordingly, the following exemption is now in effect. Computer programs where the circumvention is undertaken on a lawfully acquired device or machine on which the computer program operates, or is undertaken on a computer system, or computer network on which the computer program operates with the authorization of the owner or operator of such computer system, or computer network, solely for the purpose of good faith security research, and does not violate any applicable law, including, without limitation, the Computer Fraud and Abuse Act, and for the purposes good faith security research means accessing a computer program for good faith testing, investigation, correction of a security flaw or vulnerability where such activity is carried out in an environment designed to avoid any harm to individuals or the public, etc. Then there is an exception for 3D printing. Some 3D printer manufacturers use technological protection measures under copyright law, nonetheless, to limit the types of material or feedstock that can be used in their 3D printers. The acting register quickly adopts this one. Computer programs that operate 3D printers that employ multi-chip, microchip reliant technology that limits the use of feedstock when circumvention is accomplished solely for the purpose of using alternative feedstock, those are now exempted. Then the register goes into a number of classes that are considered but not recommended. So these will be the disappointing one, guys, so be prepared. As Carrie always says in Princess Bride, get used to disappointment. Here you go. These are going to be the disappointing ones. So don't yell at me. I'm just the messenger. Leave your comments below. Dislike the video if you have to, but I'm just the messenger, guys. I didn't make this law. Proposed Class 3, Space Shifting of Audiovisual Works. would allow circumvention of technological measures protecting motion pictures and other AV works to engage in space shifting. The Copyright Office's understanding is that space shifting occurs when a work is transferred from one storage medium to another, such as a DVD to a computer hard drive, which is not something I have ever done, I swear. The case law maintains that transferring digital files from one location to another does implicate the reproduction right and is therefore infringing even where the original copy is contemporaneously or subsequently deleted. With regard to personal space shifting, in light of the lack of record and in absence of a clear supporting precedent, the acting register found no basis to depart from the fair use analysis and ultimate conclusion reached in the 2015 proceeding, where the register was unable to determine that the proposed use was non-infringing. For example, the record included substantial evidence of extensive markets for internet-based distribution services for copyrighted audiovisual works, including digital rentals, online streaming, over-the-top services, on-demand cable, satellite television offerings, disc-to-digital services, digital locker services, which could all be negatively impacted by the proposed exemption. These markets also served as sufficient alternatives to circumvention, as they demonstrated a wide availability of easily accessible copyrighted works that could potentially be negatively affected by an exemption that allowed unauthorized copies to compete with those authorized access models. Based on the record in this proceeding, the acting register did not find that the statutory factors supported the proposed exemption. So if this exemption of space shifting was important to you, I'm talking to you, Larry from Redigi, you'll want to write to your Register of Copyrights and Librarian of Congress during the next Notice of Proposed Rulemaking in about 2 years. Proposed Class 4 audiovisual works for HDCP over HDMI. Proposed Class 4 would allow the circumvention of high bandwidth digital content protection to make non-infringing uses of audiovisual works. The acting register concluded that the proposed exemption was overly broad, as HDCP is the industry standard for protecting audiovisual works in transit to a display device, and thus limiting the proposal this way did not very meaningfully focus the scope beyond the starting point of all audiovisual works. The acting register determined that some of the proposed uses may potentially be fair use depending upon factual circumstances, but that the record lacked the requisite detail and legal support for the acting register to conclude that the proposed uses are likely to be non-infringing. So again, if you were looking forward to an exemption for HDCP, for circumventing HDCP so you can record or stream or whatever, because you think your use is otherwise non-infringing, you are still not authorized by this, and you will want to write to your Librarian of Congress and Acting Register of Copyrights during the next Notice of Proposed Rulemaking. Proposed Class 11 is for avionics. Class 11 would permit circumvention of access controls on electronic systems used in aircraft, as in avionics, to enable access to aircraft flight operations, maintenance, security, data collected by third parties upon authorization of the aircraft owner or operator and in the course of complying with other federal aviation standards. The proponents asserted that operators have faced a rise in the complexity and scope of work needed to keep their fleets secure and operating efficiently, that the FAA has mandated the review of data, information logs, and other information as a means to ensure safety and regulatory compliance. The acting register found that the record suggested the data collected by aircraft at issue consists of facts which are not copyrightable. According to the petitioner, the information represents objective details about aircraft such as flight operations and fuel economy. As public knowledge explained, the data inputs and outputs are not classifiable as a work protected under Title 17, and such access does not implicate colorable copyright concerns. The acting register accordingly concluded that proponents have not alleged that the data or data compilations they are seeking to access are copyrightable and are thus subject to the prohibition on circumvention. Therefore, the acting register determined that it is not clear that Section 1201 is facilitating any of those actions, and noted that the security research exemption may potentially be utilized to cover such activities to the extent possible. So if you are looking for the exemption for avionics, for accessing your aircraft's avionics, guess what? The Acting Register of Copyright and the Librarian of Congress, and I'm guessing the NTIA, yep, the NTIA, don't think that you are covered by copyright at all. So you don't need an exemption because your avionics stuff is not a copyrighted work. So then implementing Section 1201 copyright protection, technological protection measures is not really legal. That's not something that's going to be enforceable at law. It's not like you're violating the law by accessing it, and it's not like they're able to bring a successful claim against you for violating it or for accessing it, at least under copyright law. So then Karen Temple concludes by, or should I say, Karen Temple, your Acting Register of Copyrights, then makes those recommendations, and then the Librarian of Congress then adopts them down here. The new Part 201 general provisions are amended to read as follows. The librarian has determined that the prohibition against circumvention of technological measures that effectively control access to copyrighted works set forth in 17 U.S.C. 1201 A1A shall not apply to persons engaging in non-infringing uses of the following classes of copyrighted works: motion pictures for the purpose of criticism or comment in documentary filmmaking, non-commercial videos, non-fiction multimedia ebooks for educational purposes by colleges, universities, massive online courses, educators for libraries, museums, and other nonprofits, for circumvention by disability services, for kindergarten through 12th grade, for accessibility, motion picture clips and things can all be used. Literary works distributed electronically that are protected by technological measures that prevent read-aloud functionality are allowed to be circumvented when such a work is lawfully obtained by a blind or other person with a disability, when such a work is a non-dramatic literary work lawfully obtained, or. That's an or, guys. That means that you can, if you are blind or otherwise disabled, within the meaning of 17 U.S.C. 21, you can circumvent technological protection measures for anything. And then if you are not blind, guys, if you are not blind, not disabled, you can still access a non-dramatic literary work. So basically a non-fiction work. That's really awesome. That means not read-aloud technology is completely legal, and you're not circumventing something by enabling read-aloud on a Kindle book or something like that when you normally have to pay for that. Literary works consisting of compilations of data generated by medical devices that are wholly or partially implanted in the body, where circumvention is undertaken by a patient for the purpose of lawfully accessing the data, etc. Computer programs that enable the following types of lawfully acquired wireless devices to access a mobile telecommunications network when circumvention is undertaken solely in order to connect to a authorized telecommunications network authorized by the operator of such network: wireless telephone handsets, cell phones, all-purpose tablet computers, portable mobile connectivity devices such as hotspots, wearable devices such as smartwatches and fitness devices, computer programs that enable smartphones and portable all-purpose mobile computing devices to execute lawfully obtained software applications where circumvention is accomplished for the sole purpose of enabling interoperability or to permit removal, so you're allowed to jailbreak to remove stuff. Computer programs that enable smart televisions to execute lawfully obtained software applications, which also includes enabling interoperability. Computer programs that enable voice assistant devices to execute lawfully obtained software applications, as long as it's not done for gaining access to copyrighted works. Computer programs that control the functioning of a personal automobile are allowed to be accessed where circumvention does not constitute a violation of applicable law, including limitations from the Department of Transportation or Environmental Protection Agency. Computer programs that are contained in or control the functionality of smart home appliances or home systems, such as refrigerators, thermostats, HVACs, electrical systems, where circumvention is necessary to allow diagnosis, maintenance, or repair, and is not accomplished for gaining access to copyrighted works. computer programs where the circumvention is undertaken on a lawfully acquired device or machine for good faith security research, does not violate other applicable law, including the CFAA. Video games in the form of computer programs embodied in a physical or downloadable format when the copyright owner has ceased to provide access to an external server that's necessary solely for the purpose of permitting access to allow copying and modification of the computer program to restore access to the game for personal, local gameplay on a personal computer or video game console. Oh, well, let's just take a dog break here since we're getting a dog break. Let's just have a dog break.
For a dog break.
We'll take a dog break.
Dogs.
Hello, dog. Hup, dog. Hup, dog. Hup. If you want a treat, you have to come hup. I will let you starve. Hup. Come on. Good boy. Oh, he thought about it for a moment. He did. I think Ilsa's still outside. So Ilsa's not getting any treats.
Maybe you should just quickly let Ilsa inside since she was barking earlier.
Okay.
Sure
but Nico's on my lap.
You.
But Nico's on my lap.
You're so adorably cute. Alexa, tell a joke.
Ilsa.
Get Alexa to tell a Halloween joke.
Alexa, tell a Halloween joke.
Why didn't the skeleton cross the road?
I don't know.
He had 1 foot in the grave.
I mean, I probably love this more because it was Alexa that said it. Where's Ilsa? Oh, there's Ilsa. Ilsa!
Alexa is winning me over.
Up. Oh, that was a very affirmative. Up.
Visiting Leonard, I only literally regret one thing. I literally did not take advantage of Alexa. I really should have.
Nico. Oh. Ilsa, can you come up? Yes, you can. Good girl. Okay. Permitting access to the video game to allow copy modification. To restore access on a personal computer or video game console when necessary for preservation in a playable form by an eligible library, archive, or museum. There's also an exemption for video games that do not require access to an external computer server for gameplay and are no longer reasonably available in the commercial marketplace solely for the purpose of preservation by a library, archive, or museum in playable form. And for computer programs used to operate video game consoles, also solely for preservation in a playable form by eligible libraries, archives, or other museum. Then the exception for computer programs that operate 3D printers that prevent alternative feedstock. And then there's this final section here that's kind of interesting. Persons who may initiate said circumvention in any form. To the extent authorized under paragraph B, the circumvention of a technological measure that restricts wireless telephone handsets or other wireless devices from connecting to a wireless telecommunication network may be initiated by the owner of any such handset or other device, by another person at the direction of the owner, or by a provider of a commercial mobile radio service or a commercial mobile data service at the direction of such owner or other person, solely in order to enable such owner or family member of such owner to connect to a wireless telecommunications network when such connection is authorized by the operator of such network. So that seems to be a specific exemption to say that just in case anyone was unclear, that the providers can also unlock the phones or whatever as part of their providing service. And so this rulemaking has been enacted by Carla D. Hayden, the Librarian of Congress. It is not signed there, but I'm assuming that the signed copy went to the right places and whatever. And it's my understanding that this is now good law. And so that is where all the different articles are coming from that say that the right to repair has been protected by the Librarian of Congress and all that, and that is very true. There are several sections to the right to repair, and so there were actually, about 7 different things that were renewed or enacted there, and a few others that were not. So let me know what you think of that in the chat and the comments, and we'll start living in this new reality for the next 3 years with all these exemptions, and then we'll make comments and things, right? We're going to all make our comments on the next notice of rulemaking in 2 years.
Also, Leonard, early on, Kotaku at the beginning of this asked if console makers use DMCA 1201 to stop unlicensed games running. Would that be a misuse of copyright?
No, that's what it's there for. That's what it's there for. So you're saying if someone used a technological protection measure to stop a console from running an unauthorized game? Is that the question?
Like what he said is video console makers use DMCA 1201 to stop unlicensed games code running. Could that be a misuse of copyright? That was his exact question.
So it certainly could feel like a misuse, but it is exactly the opposite of that. That is the purpose of Section 1201, is to allow any copyright creator to enable, create, implement, whatever, a technological protection measure to protect their copyrighted work from further use. So you're asking something about something ever so slightly different. Could a console maker use that to prevent unauthorized copies? Well, yeah, that's still well within the purview of copyright law. And to prevent the unauthorized copies is exactly what technological protection measures are supposed to do. So you're really looking at two sides of the exact same coin. And whether it's to enable protection of protected copies versus enable the prevention of unauthorized copies. They're both the same thing. So the technological protection measure is authorized by copyright law, and where it starts to fail is when it's no longer protecting a copyrighted work. For example, in the avionics exemption, the Register of Copyrights, Librarian of Congress, and the NTIA all said, this isn't copyrighted. There is nothing here that's copyrighted. The data you're accessing in the avionics doesn't appear to be anything that's a product of a copyrighted work. So you should not have any issue with copyright in circumventing technological protection measures. You might have some other issue because this is only about copyright, but as far as copyright circumvention, you can't use copyright technological protection measures to prevent access to, say, things that aren't protected by copyright. So if you're trying to claim that you are protected under 17 USC 1201 A1 because you enacted a technological protection measure to prevent access to a mechanical system. Let's say that you made a door lock. Let's say that you made a door lock and somebody broke through the door lock, and so you said, oh, you circumvented a technological protection measure. I was protecting the things behind the door. I'm literally meaning a physical door and a physical lock. Well, that's not copyrighted. That's not a copyrightable thing. Maybe we could get into whether you're trying to use a technological protection measure to protect the software that runs the door lock. That's different. But if you're talking about protecting the thing behind the door, it has to be a copyrighted work. And so these technological protection measures are more digital protection measures to protect. Maybe there could be an argument made like if the door was protecting artistic works or something, but those also aren't necessarily digital works. So that might not fall within another definition in copyright law. Sorry, Kaylee, go ahead.
Just to basically highlight Kotaku's comments that he made after having the question, it's like if I made a game run on the Xbox, that's not copyrighting anything, but it's not protecting any copyright work, but always preventing my own game from running, which was his comment after it. So is he still allowed to, let's say, if a game is running on a certain type of program, is he allowed to basically make it run on a different system just so more people could enjoy that? Would that be allowed? Well,
a different system would be space shifting or whatever, and the copyright owner is allowed to protect their market for that. So in other words, if something doesn't run on Xbox One, but it did run on Xbox 360, and you can easily make a modification to make it run on Xbox One, you still might be circumventing a technological protection measure illegally, because the copyright owner is allowed to prevent access to those those things and then get paid if you want to play that game on Xbox One instead. There is no requirement of backwards compatibility or anything. Now, Kotaku also proposes the example where someone is making a third-party game, and let's say they didn't want to pay their Nintendo validation fee or whatever. It's something like $5,000 or $35,000 or something like that, depending upon the size of your game and how many improvements you need to make to it, how many patches you send and all that stuff. That if you're a developer and you're publishing your game to one of these platforms, it has to be validated by the platform itself, like by Nintendo or by Microsoft or by Sony. So you send your game to them for validation. Well, they don't just sit there and do that for free. They charge a fee. And if you don't validate your game through them, then your game doesn't run on their console. And if you then circumvented a technological protection measure to get your video game to run on their console, that might be fair use. That might fall under one of these exemptions. You would have to be very careful not to go further than that. You are also distributing said sub-technological protection measure, sort of, as in if you make it part of the code of your game and then distribute your game. So let's say that I wrote a game that could run on Nintendo Switch, and it wasn't allowed to run on Nintendo Switch because you have to insert a cartridge and the cartridge has to validate. Or you have to download a thing and it only downloads from authorized sources. So if I figured out a way to make it run on my own cartridge that I made myself, and it would run on the system by circumventing those validations, is that covered by these exemptions? No, I don't think that's covered by these exemptions. It might be covered by something else. I don't want to end the inquiry there. But so far, no, I don't think the law is terribly in your favor on this one. I think Nintendo, you'll have an uphill fight, but let's forget that you'll have a fight. If we were in a hypothetical world where you had unlimited resources to fight, it would be a good fight. It would be a worthwhile fight, I think, to find out whether Nintendo really can control access to its hardware with a copyright technological protection measure. And if they did, yeah, that might be misuse of copyright. I don't know what it would invalidate beyond the technological protection measure itself. I don't think it invalidates all of Nintendo's copyrights. Because remember, misuse of copyright invalidates copyrights. But if a successful misuse of copyright thing was done, I think it would invalidate any copyright or violation of the technological protection measure. That's it. Well, how did I do that? That was 85 pages of Copyright Office rulemaking document that we got through in less than an hour. How much do you love me?
I did have one question. Again, Kotaku brought it up.
Not allowed.
That
I already asked you one.
But how would the exemptions affect warranty? Because there are certain warranties that say that you can't try to fix something on your own. And so if there are copyright exemptions, would that affect warranty at all?
So this is just copyright. And while arguments can be made, they're just going to be arguments. This says that if you circumvented those technological protection measures on your computer game or your refrigerator or whatever, they can't come after you for a violation of copyright law. Apple can't sue you for violating copyright law or whatever under these circumstances. So Louis Rossmann might be able to do some of his work under these exemptions. It means that Apple isn't going to sue him, but it doesn't mean that Apple has to open up a right to repair program or make him an authorized or anything. That lawsuit, that claim, that dispute is still going on. And this just maybe adds fuel to that fire, and maybe an argument, maybe in court someone can say, by the way, Your Honor, also the Librarian of Congress has made an exemption for this kind of thing. But it doesn't mean that copyright owners have to accommodate the right to repair or won't continue to fight your warranty claims. If you jailbroke your phone and then took it to Apple under warranty for a hardware issue that had nothing to do with the jailbreaking, that doesn't mean Apple is not going to say, oh, you broke your phone. Now we have to do all sorts of checks to find out if it caused the hardware problem, and we're just not interested in doing that, so have a nice day. That's still a fight that you can have in court. and you might still have to have that in court. All right, well, I think that's our show, everyone. We almost skipped one story that was just worth mentioning. If you guys remember, Tiara Y's video was taken down, the Rick and Morty, Denver Fenton Allen, Justin Roiland voiceover that Tiara Y then did a full animation of, and it was taken down by Adult Swim like 2 weeks ago or a week ago or whatever. Just a quick update, if you didn't know, that is back up. Tiara Y worked it out with Adult Swim. I don't know what the terms are. There is a Reddit thread on it, but just worth mentioning that did go back up, and that's really the way to do it, is to get authorization. As much as that sounds kind of stupid, that is the way to do it. You have to get permission. If you were Justin Roiland and you created Rick and Morty, you would want people to get some kind of permission too. Even if you're easy, even if you're benevolent, you're going to want something. You're not going to want people to just go willy-nilly steal your copyrighted work. You want to get paid for your hard work and recognized for it. And so I'm sure they worked something out. I don't know what the details are, but it would make sense to me that there was some kind of either kind of sharing agreement where like revenue went to Adult Swim, or Tiara Y signed some kind of agreement to not do it again, or so. I don't know. There would probably be some kind of consideration for that. So thank you for joining me, everyone. I am Leonard French, your favorite copyright attorney. With me, of course, has also been Kurt Mueller, your favorite patent attorney, Ms. Kaylee, a tactical, and I think Brandon was in there for a little bit. I know he was not feeling well with his neck and all that. So thank you all for joining us. Thank you for our October supporters. This will be, I believe, the last live stream of October. Thank you to our $50 Patreon supporters on patreon.com/LJFrench. In October, our $50 plus supporters are Jonathon Doe, John Steele, Gavin Barnard, Eevi, Andy, Kyle Mudrak, Verement, Tayne, Sean McNamara, William Gonzalez, Michael Pearce, Grunkle, Tia Marie, Terry Crisp, Richard Fournier, Michael Jones, Spirit Bear, and Jan Negrey. And thank you to all of our $5 plus supporters that will be scrolling on the screen and are currently scrolling on the LED panel behind me. Really appreciate you all. This is a community-supported channel, which wouldn't be possible without your support. So, looks like Nico is back. So we'll take it out with Nico. So thank you very much for joining me. Nico, you want to come up and say goodbye? Come on. Hop, hop, hop. Go boy. Go boy. But I think we've attracted an Ilsa because every dog likes treats, right? Every dog likes treats. And so if there's treats involved, there have to be a dog. Right? Okay, go lay down. Go take that, go lay down. So Ilsa can come up. Go lay down. Ilsa, up. Ilsa, come. Ilsa, up. Oh, good girl. Good girl. Okay, don't hurt yourself. All right, everybody. Love you all. I am Leonard French, your favorite copyright attorney. Have a great week. I'll see you in the VODs that drop and any of the edited videos. I know we have a special one to do this week. We'll see if we can get it done. Love you all. And there's my camera. Bye. And here we have Nico the squirrel.
Aww. Oh, he's so tolerant as
You're
well.
so very tolerant. Oh, you're so good boy.
So where's your moose hat? That's the real question. I could've brought my moose hat.
Moose and squirrel.
Yeah, I have a moose hat, you know?
I'm swooning so hard right now.
That's moose and squirrel. Alright, so far I haven't figured out how you're supposed to hear me through this thing. So this might not work as well as I originally planned. Also, I'm not sure how a big golden retriever mask and trap music work together, but happy Halloween.